So today we are back with another Twitter Spaces session. So usually we have sessions on sitting days, but today we are having this session on the need to reform the justice system, featuring Honorable Dr. Vijayadasa Rajapaksa, Minister of Justice, Prison Affairs and Constitutional Reforms. Especially because the next sitting week, 6 bills are to be taken up for debate. So if I just name them, so the Poisons, Opium and Dangerous Drugs Amendment Bill, Notaries Ordinance Amendment Bill, Powers of Attorney Ordinance Amendment Bill, Wills Ordinance Amendment Bill, Registration of Documents Amendment Bill, Prevention of Frauds Ordinance Amendment Bill are scheduled to be taken up for debate, and also on the 20th and the 21st, the 22nd Amendment to the Constitution Bill is also scheduled to be taken up. So we've been having these spaces, the communication department has been facilitating these spaces for quite some time, so you know how to connect with the minister. You can leave your questions under hashtag LKAskMP. So I must highlight, if you are to send us a question which you want to direct to the Honorable Minister, please ensure that you mention the hashtag LKAskMP, or you can join in live and ask a question, and we kindly request all of you to not wait until the last moment to ask questions. This session is done in English, but you can present your questions in all three languages. Simultaneous interpreters are on standby, so feel free to connect with the minister with all your suggestions and concerns, and he will directly answer to you. So good morning, Honorable Minister.
Good morning.
So the next sitting week is pretty much justice oriented. So before, I mean, we've had a couple of questions which we have received under the hashtag, but prior to moving into those questions, let's talk about these 6 bills. So a lot of bills coming in. What sort of changes do these bills wish to make?
These are really essential bills to be reformed or amended, for the reason that one of the reasons is most of the bills had been enacted at least 150 years ago, and that they were quite suitable during that period. Now the world is changed, the technology has bypassed all those things. Due to certain lacunas and lapses in the existing law, people have to face a lot of difficulties, especially that 5 bills that you referred to, registration of documents, prevention of frauds, notaries, wills and power of attorney. Now all these 5 bills are related to the transactions of immovable properties, and there is a large number of cases pending almost all the civil courts all over the country due to the fact that there had been so many fraudulent, forged documents, the deeds that had been executed. That had facilitated for these culprits to do it because of these lapses in the law. And sometimes even unfortunately some professionals, those who are engaged in this executing legal documents also, that's contribute a lot for this kind of corrupt practices. Therefore, that it's a duty on our part to ensure that we must not leave room for that kind of forgeries and fraudulent transactions.
Right. So if we talk about the drugs and the poisonous drugs and opium act, so what sort of a change, because we received a determination from the Supreme Court also, I think the last sitting week.
Yeah. So now there are also that basically when this act was passed, that has caught up the drugs, dangerous drugs that prevail in the society at that time. Now so many new things had come up, like ice, I don't know the names, so much, the large number of the brands, varieties had come into the society, and the younger generation is getting really ruined as a result of this menace, and we will have to control this. Also that we are at the same time considering, since there is a large number of drug addicts in Sri Lanka, and all those persons have been sent to jail in at sometimes instances that they are not, they are non-bailable offences. Therefore, that they will have to keep in the custody. Now, our prisons also overcrowded, whereas that they can make accommodation for maybe 13,000 people. Now, last week it has gone up to over 24,500. In any event, much more than that, we are concerned as to how these people can be rehabilitated instead of imposing punishment. At the moment, that unless there is a court direction, that we cannot accept anybody for rehabilitation. And now we want to make changes in the law just to have some the liberty for them to get these services without going to court, because in our society, if you have to go through the court proceedings, it looks rather, it's a stigma in that family, and others can't face the society. Therefore, that's we are trying to encourage that voluntary rehabilitation too.
Right. So, I mean, without taking much time, I wish to, since we only have about an hour, so I wish to move into the questions from the general public. Minister, we've received questions under the hashtag LKAskMP. So, Dinidu D. Alves has asked 3 questions. So, if I present to you one by one, the first question he asks is, it's been nearly 50 years since Sri Lanka last executed a person. Why not formally take the steps to abolish the death penalty?
By keeping that death penalty, no harm will cause. At least, that we know President had executed. In fact, when I was the minister in 2015, then I consented for the moratorium also in the UN, though that is there in the law. We are not going to execute this penalty. There are 2 opinions, that some people say that this has to be abolished. The other people's opinion is that they should be executed. We are in between. We keep the law valid and without executing people. We will have to go for some debate, because that so many controversial opinions. I think it's a good point for us to consider and to take a firm decision, taking into consideration that the the opinion of in the most of the country, international communities too, they are basically say that just because that you executed the people in certain jurisdictions, the number of crimes committed had not been reduced. It's a matter for research, in fact, that we'll have to think about seriously.
Right. So, he wants us to ask, ragging in universities is a law and order problem as much as it is a social problem. In 1954, Ruby Bridges was given US Marshals protection to go to school. Why are we not extending security to our university students?
That is a good question. In fact, that when Honorable Richard Patirna was the Minister of Education, he enacted the University Ragging Act. Till 2018, for a period of 20 years, not a single action had been taken. But when I became the Minister of Higher Education in May 2018, I had to implement the law. During that short period, that there were, I think, about 45 students. Those who involved in this inhumane ragging were arrested and kept in detention for some time, because the magistrate has no power to grant bail. They have to go to the High Court. But I do not say that is the best method that we have resorted to. All these students who engage in this kind of things are misguided people. That there are, that frustrated political forces behind this. These are not that students voluntary thing. When they are selected to universities, that there are some the forces, they go behind them. Not all. If a student is an affluent person, if the student's parents are educated, they don't go behind them. Then people with the students with that's the difficulties, economic hardships, only that's they in the first instance follow, and they do the brainwash. That is why I said that there is a this frustrated political groups behind this. I think that for the betterment of the country and to safeguard the lives of the children, we'll have to have some method.
Right. So, Honorable Minister, don't you think that our justice system has a lot of age-old laws which needs reform, and for all this time that we have quite not been progressive in reforming the laws, and even if we move into such reforms, or if we debate or talk about those reforms, it very rarely sees light. So why do you think for all these years this has been?
Yes, I'll come to that point. I thought of adding something to the previous question. Now you can remember since 2015 that there was ongoing the day-to-day hassle all the people had to face, because everyday university students, medical doctors, they were on the roads for a period of 3 years that our medical faculties could not function properly. Around 952 students in Saitam, they couldn't study, they were just idling, and so many that's the propagandas, rallies, strikes in the hospitals. According to the intelligence report, there had been 410 protests, 410 protests within 3 years, and all the medical faculties were defunct. When I became the minister in May, then I had a discussion, progressive discussion with all of them, and within 1 week I convinced them that they are wrong. Finally, that I brought a law, and it was enacted in the parliament, and I saved 950 students, medical students who were at Saitam, by absorbing them into Kotalawala Defence University. Now all have become doctors. Now for what these university students were on the road for 410 days. What a crime, what a wastage. What they have achieved? Nothing. The second question, all archaic laws, we concede, not been duly properly attended for a longer period. That is why I mentioned that some of these bills, some of these ordinances are 150 years old. Now we have selected one by one and we are reforming. In fact, that there are 6 bills here. There are 30 to 40 bills on the pipeline within next few weeks that I will bring to the parliament. We are attending to do all those things and trying to introduce and update all the laws and enactments, that is just to fit into the present social requirements.
Right. So, Honorable Minister, his final question is with regards to the PTA. Almost all crimes under the PTA can be still prosecuted under other existing laws, murder, damage to property, etc., etc. Other than for holding suspects with very little oversight, what is the rationale for keeping the PTA or bringing in a new replacement law?
In 2015, as the Minister of Justice, I initiated as a government decision when the present President was the Prime Minister. We really that's very keen to replace it with a new law. Therefore, that we engage in the process of drafting. Then we drafted the Counter-Terrorism Act bill. At the time that it was in progress, what happened was that there was an incident, that is Easter Sunday attack in 2019. With all that, there was a public opinion created that without the PTA that they cannot face the situation. Therefore, at that time, of course, that I was not in the cabinet, but the government had to face series of other issues. It was neglected. Now again, and when I commenced my assumed my duties as the Minister of Justice, now I have looked into all those matters and I have appointed a committee to draft a new law taking into consideration the previous bill, then to replace this PTA by that law. The process is going on.
Okay. Okay, so Dinidu, I suppose your questions were duly answered, and if so, we have a lot of people joining in. So we have the Minister of Justice with us for over about an hour, so up until 10:30. So if you have questions, you can talk to him live, and he will take up your questions, your suggestions. If you have constructive criticism, we're all open to it. So please send in your questions under the hashtag LKAskMP, or raise your hand and we will take in your question. So Honorable Minister, there is another question from Professor Chandana Gamage under the hashtag, could we legislate every court decision that every court decision is given as a written order containing the facts considered and rules of the law applied? That way, when a higher court overturns a lower court decisions, we might learn something. So he's asking if that is, do you want me to repeat it?
I think that is the factual position he has raised it.
Okay.
But it doesn't mean that there is any question. That is the prevailing system.
Right.
Whenever you have to give a judgment, whether it is in the original court, then you will have to give reasons as to how he did come to the conclusion, as to how that he had analyzed and applied the law. And if it is an appeal from an original court to the superior courts, the maybe High Court or Court of Appeal, even Supreme Court, if they have to reverse or affirm, that they still that they will have to give the reasons, because the judgment may be correct, but it cannot be recognized unless that judges give the reasons as to why they came to that conclusion.
Right.
Therefore, not only that justice to be done, that it seems to be that they have done the correct thing, and therefore it's the norm that has been followed in all these democratic countries.
Right. So we have 3 requests who wish to talk to you, Minister. But before I move on to that, I have another question on the LKAskMP which I wish to take from Domidu. And it's regarding the Rent Act. The current procedure to recover possessions of a premises given on rent is a time-consuming rent, and the ejectment action which can typically go for years. Last year there was talks of a new Rent Act, but nothing materialized. Any plans to change this? If so, when? So I remember Honorable Ali Sabri, when he was Justice Minister, brought in
there is a long history.
Yeah.
In fact, this Rent Act and Ceiling on Housing Property Law were introduced by Mrs. Bandaranayake in 1972 and 73, and it was justifiable during that period because that was not a open economy, and that there were a group of people who were owning most of the houses and the lands in the cities. That was quite fitting at that time, but later on, with this open economy and after the passage of the time, in fact that there is no necessity of having a Rent Act. In 1995 to 2000, when I was the chairman of the Rent Board of Review, even my opinion was that has to be abolished. Select committees were appointed. I think they made mistakes by appointing the MPs to the select committee, especially ministers elected from Colombo district. They always go by the public opinion. They were scared because they might lose their vote base, and they didn't want to proceed it. Now again that we appointed a committee, that they were working on it, but halfway through again that was that stall. Now my predecessor Mr. Ali Sabri had appointed a committee. Now that committee had studied this in full detail, and there is one draft. These rented and lease out properties, there are 2 categories. One is the premises governed by the Rent Act. Those are statutory tenants. Others are ordinary tenants or lessees which are not governed by the Rent Act. Now with regard to those premises, the lease premises, there was a draft that we have improved it. In fact, that I sent it to the Attorney General 2 or 3 weeks ago. We have got the clearance, COC, certificate of constitutionality. I have sent it to the cabinet. This Monday we may be able to get it approved.
Get it right. So we can
With regard to the Rent Act,
right.
also I have given some instructions to the committee that I am waiting for that their report.
Right. So I think we can look forward for a progressive change, a reform.
That need, especially, and you look at the Colombo Fort, you look at the Colombo Kandy City Centre, Gold City Centre, Kurunegala. All these, the dilapidated buildings are there, so ugly and are very non-productive. That is because that most of them are rented out. The landlord cannot eject them, and tenant can't do any structural changes. But if you look at the new towns where that the properties are not governed by the Rent Act, like maybe Dambulla, Ambilipitiya, Ambalantota, that those cities are flourishing, and therefore this is an obstacle to the development of the country. That we will have to do some drastic changes.
Okay. Right. Thought I would love. So Olivia Thomas wishes to speak to you, Minister.
Yes.
Olivia, if you're with us, you can talk to the Honourable Minister now.
Hi, sir.
Yeah.
I'm a practicing lawyer.
Right.
One of the biggest, one of the most common problems that the profession is facing is that, like, as you know, a lot of litigants have lost their faith in the justice system.
Yeah.
Quite apart from the law enforcement aspect of it,
Yeah.
I think most of it is because the amount of time they have to spend in litigation.
Correct.
If you go to a district court even today, you would see that there are cases pending from like 2012 and 13.
Correct.
And in the Supreme Court recently, I came across a case that was pending in appeal since 2009.
Yeah.
I wonder what is it that we are doing differently from the first world that is taking us so long from expediting our cases. One thing is, yes, as you may know this a lot more than me, sir.
Yeah.
Most of these cases have not reached conclusion because they're still in appeal.
I know.
Matters that were perhaps instituted in the 1990s or the 1980s, they have gone from one court to the other and they're still in appeal. What is it that we can do as a country to cut short this litigation process? The sad part is, a lot of lawyers, it's actually quite sad, they've drawn inspiration from being able to take an unreasonable amount of time in litigation. They're also now applying this to arbitration. And the whole purpose of ADR is also defeated by these practices of getting, unnecessarily delaying the process.
Right.
What do you think, sir, it is that we can do to expedite legal process?
Right.
Right. Okay. Thank you so much, Olivia. So
I think that is Olivia's that experience is the same as of my experience, that I have practiced from magistrate court to the Supreme Court, and all over that this is a problem. In fact, that we wanted to address this issue in 2015, that we addressed from many angles, just to reduce the large number of cases, especially where that you need not take the long we'll say that's the large amount of the time to be spent for some cases are really absurd. And therefore in 2015 I amended the mediation board law. As a result, that the threshold was increased from 250,000 to 500,000. Normally during that period annually they were getting about 100,000 applications, but by doing that, we made it 200,000 in the mediation boards. That means at least 50,000 cases were reduced from going to these civil courts, because those are small matters below 500,000. In addition to that, we established special media boards in the northern and eastern province to resolve the land issues. Then now we are concentrating, and in fact that we have started in few other places also. That is where, because when there is a big case, maybe about 100 million or 200 million worth property is a subject matter of a litigation, and similarly if it is a property worth about 1 million, the court has to spend the same amount of time, and therefore that's we wanted to cut short the procedure, and for that we have taken a further step, that those bills also in the parliament, maybe in the next session, that we will have to take small court claim courts. Then we will filter small claims, we will filter through different mediation process, and rest of the cases will remain in courts. In 2015, the disposal rate in the Attorney General Department, disposal rate means if you get 100 cases per year, you dispose only 65 cases, then 35 is accumulated. Then we restructured the system. In 2017, when I left the ministry, that 65% ratio had gone up to 105. Then in the government analysis department, their disposal rate was only 68%. As a result, what happened was, every day when the cases are called, we are waiting for that government analysis report postponed. That was happening in every court all over the country. But we upgraded the 8 laboratories which were in this government analysis department. In addition to that, I got some grants from Korea, roughly about 500 million worth. Then we established 2 new laboratories, that is DNA, because we didn't have that facility at that time. Now you need not send the blood sample to overseas, we can do it here. Then digital transaction, digital forensic laboratory. With that, within 2 years we made it 100%. Monthly if you get asked 6,000 reports from the department, they give all the 6,000. That we updated all those things. And I introduced again the pre-trial proceedings in civil cases. Before you commence the trial, you discuss the matter with the parties, lawyers, judges all together, and make every endeavor to see the possibility of settlement. Large number of cases are settled. When a case is settled, it is good because both parties happy. That's if judgment is given, one party is always aggrieved. That is working very well in some courts. In some courts, it's a poor performance. The reason was, that some of the judges, realize this. They see the importance of it. Some of the judges not. There was an issue on our side also, that we couldn't have enough time for any kind of the awareness programs, training, especially due to the intervention of this COVID and economic crisis. There was a delay. Now that the similar provision had been introduced to the criminal courts also. If you look at that, the statistics we have through ADB, we are doing a survey. What that lawyer said is correct. Now that there are new dimensions that we have found. If you look at that, the amounts that you are spending for labor tribunal is huge. One case per maybe 44,000 roughly. In the debt conciliation board 12,000 rupees, but in the district court is concerned about 2,000 rupees. That clearly shows our financial policy is wrong. That we are going to adjust it. Report is not yet finalized. I hope to get it in the course of at least before the end of next month. Then we want to do a very drastic the reforms in the legal system.
Right. So we have Chanchala Gunawardana who wants to connect with you, Minister. She's connecting. Chanchala, you can unmute your mic and forward your question or suggestion. Or Chanchala. Chanchala, your mic is on mute, so you have to unmute.
Others will go to the next.
Yeah, so she's there, so we'll go. We have Kumar who wants to connect. Kumar. you can, he's still connecting. Right. Kumar, you can unmute your mic and okay, so
We'll go to the next
yeah,
question.
we'll go to the next question. So Bishan under the hashtag LK Ask MP is asking, what can be done to make judges accountable when blatant errors are made? Can there be a review process so that judges unfit for duty can be removed, punished by independent authority?
That independent authority is already there. That is the Judicial Service Commission. That is consisting of the ex officio, the chairman, chief justice, and two more senior judges of the Supreme Court. But of course, in the performance of their duties, if there is an error in the lower courts, then still that the appealable rights is there to challenge it in the superior courts. If there is any misconduct or any other kind of issues, certainly that anybody can complain to the Judicial Service Commission. That Judicial Service Commission can look into all those allegations. Sometimes that there are cases where the Judicial Service Commission appoints a judge to inquire into the allegation of the judges of the lower courts, the original courts. But if it is an allegation against any misconduct or mischief on the part of the superior courts in the Court of Appeal and the Supreme Court, the Constitution has provided for impeachment. That is the only provision, to check to evaluate that and to take a decision with regard to the conduct of a judge. Even in the Parliament, that is immunity extended to the judges, not only in our jurisdiction, in almost all the jurisdiction that is there. That without that immunity, judges also can't function. Of course, it is an error on the judgment, no harm that they can do it. But if it is in the Supreme Court, whether it is right or wrong, that you will have to accept, because there is no any court about that.
Right. Okay. So Chanchala, you're there.
Hello.
Right. Okay, so both of the y'all are right. So if we can have one person, can we have Chanchala first?
I think we're both unmuted at the same time.
Yes. So we'll have Chanchala going in first.
I'm out. Please check my profile.
No.
I asked a question. I am from UK, ma'am.
Okay, right. You can forward your question, Kumar. What do you want to ask?
Yeah, sir. Sir, when
Madam.
Yes. Kumar, we can't hear you.
Yeah, when President arrived in UK,
Okay.
that time he meet with our diaspora team, Northern Province Investment Trust Organization. He will make an act to make it to invest in northern part and Sri Lanka. How about that situation? That law also I sent in my institute. Please check it, sir.
Right.
Right. Okay. Thank you. Thank you, Kumar.
Shall
Yeah.
I?
You can respond.
Yes, that there are a lot of concerns, especially just after the conclusion of the war. The basic duty is to build the areas affected by the war. In addition to that, basically just to build the trust and confidence among all the communities, the reconciliation purpose. In fact, that we have taken a lot of steps. When there was a resolution in 2015 in the UNCHR Geneva against Sri Lanka, then we co-sponsored and we made a lot of commitments. As a result of those commitments, we started the Office of Missing Person, which is been properly functioning now. During last few years, we concede that there were a lot of lapses and almost they were defunct. But we have started now during last 3 to 4 months time, they have done over 1,200 inquiries, whereas in the previous committee, for a period of 4 to 5 years, they had done only 65 cases. Now I am trying to complete before the end of next year. Then the reparation office is there. The payment to the victims, last week I got the cabinet approval to increase from 100,000 to 200,000. Then the unity and reconciliation office also continuing. In addition to that, in 2015, that most of the people who were under the PTA and involved in the LTT group were released as much as possible. Then I established 2 high courts, one in Colombo, one in Anuradhapura. We wanted to accelerate and conclude the thing, and we did it. But still that there are some few cases, about I think 23 persons had been convicted. About 21 cases are pending in courts. Now we have taken steps to accelerate those cases also to be concluded very early. In addition to that, there is a committee, expert committee chaired by former Chief Justice Asoka De Silva. He has made some recommendation with regard to detainees. We are gradually implementing those matters. And I have spoken to diaspora people. I had a couple of Zoom meetings. Those leaders in many countries, including UK, Canada, France, Germany, Indonesia, Australia. I have discussed with them. Now I explained them. Now we concede that there had been vast devastation. All the people suffered. It is not confined to one community. All the people, they suffered enough. So many loss of lives. The issue is now either side, that those who are responsible of creating a war are not among the lives. Then our issue is at present as to whether still we continue with fighting among ourselves, or whether we should finalize these things and allow the next generation to live in peace. And therefore we are still struggling as to how that we can build this bridge in between the communities. There was a lot of misunderstanding and distance among the Sinhalese and Muslims after the Easter Sunday attack. Then as a result of the LTT war, we got distance from Tamil. We'll have to eradicate that situation. Now we are building the peace. President is very keen, as he said, not only to have a economic zone, that we want to get involved with all Sri Lankan, whether it is Tamil, Sinhalese, Muslim, makes no difference. This is the motherland of all of us. We must have the same feeling, that just because you are Tamil, you cannot have a different feeling to your motherland in difference to what I have. And we'll have to make all together. Sri Lanka is unprecedentedly in a very difficult situation. We expected, of course, we knew this happened, but the rulers who were during last 2 to 3 years, they didn't want to heed to our advice, or that they didn't want to have any kind of regards. Now as a result, what happened? They are really suffering, we are suffering, the country is suffering. So we'll have to get over from this one, as the President promised. In fact, that not only that, we are going to invite all the diaspora leaders to come to Colombo or to Jaffna. We'll go to Jaffna. We need not go to Geneva or UN headquarters to respond. We will get together. All the Tamils, Muslims, Sinhalese get together and we'll resolve it in Sri Lanka. Whatever the problem, what is the use of giving our explanation into Geneva? If the Tamil people are friendly with us, if we can maintain our brotherhood, that's more than enough. That is what we are going to do.
Okay.
We are committed to it.
Right. Thank you, Minister. So, Chanchala, you can. Yeah.
Sure. Great. Good morning. Firstly, I want to thank Parliament and also Minister for this opportunity. Parties viewed it before, and it's been a great step, I think, some direct democracy in action. As we are talking about looking and reforming and reviewing old laws, one I would obviously like to draw some attention to is this Victorian law of 365 and 365A articles on the penal code. I know previously certain parties and ministers have also felt, this as remarks the words mental illness regarding brothers and sisters who identify the LGBTQ family, but I think we also know resoundingly now that this is a debunked assessment. And I would say, as also you would know, your colleague, my uncle, former minister, the late Mangla Samravira, I feel would definitely not fall into those categories. It has been very heartening to see, perhaps, that where the people are, the progress and or the openness the people are at regarding this issue, now being reflected in Parliament by two private members' bills, one submitted by the SJP regarding end of conversion therapy, and now the second from MP Dolabasa regarding amendments to this 365 A and 365 article. I would just like to understand from Minister, I think as you all are reviewing and reforming, I know also President Wickremesinghe has said in meetings as well that, once this private member bill is put forth, that members are simply to vote their conscience and hopefully will hopefully vote with the people who are very much, favorable to moving past this archaic moment and respecting our brothers and sisters. I'd simply like to hear perhaps your thoughts and whether, what is the forward way on this and how we can support this important change done.
Just to thank you, Chanchala. So I think under the hashtag also, Dinudu has also asked a question: victimless crimes such as homosexuality still remain on laws and are sometimes enforced. Why not we remove them to suit modern thinkers? If I remember right, Honorable Imtiaz Baki Marker brought in a private member. Honorable Dolawata brought in a private member bill with regard to this. Yeah.
Yeah, and there's resounding support from all parties, which is great to see different members representing all parties.
Yes, but a private member bill, Honourable Minister.
Right. Now, of course, that I had not made any opinion, because as the Minister of Justice, that if I have a pre-opinion, then there can't be a balanced view. And there are two opinions in the society. Now, at the time when the law was enacted, as quite correctly you said, 100 and maybe 150 years ago, in the penal code, that was fitting into the society that prevailed. Now that's the world is changed, the people got changed. Now there are new requirements, new reforms that they expect. Certainly that I have not come to any conclusion. I will not come to any conclusion, because I am in with open mind. We'll see the both sides, that then if the majority of the parliament is agreeable, certainly that we can implement.
Right. Okay, so we have another request from Nuzaik, if I'm pronouncing your name correct. Nuzaik, you can forward your question to the Minister. Nuzaik?
Otherwise we'll take this.
Good morning.
Good morning, yes.
Yeah, and I thank Parliament and also for being available here. And my question is regarding the law college amended Gazette recently in 2021. So on that, there is a criteria for entrance exam for in A level, which is 2CS, which was amended from 3C. Now my question to the Honorable Minister, how fair it is, because across all A-level streams, there are different curriculums and the difficulties also varies. So the student, from a student to ask a chemistry or the biology student, to ask C from that student to enter to the law college, how fair it is, and also law college subjects are also not relevant to those subjects as well. And how do you take that, Honorable Minister?
Yeah, there is an issue with regard to that. It's a few issues. One thing is, if somebody wants to enter into the medical faculty, in the A-level classes, in the A-level examination, they sit for subjects which is relevant to that field. If it is in engineering, still the same. But in the subject of law, there is no such restriction that anybody who has done whatever the subject they can enter. And from time to time that there had been some changes. Basically, this new requirement, this amendments was made by my predecessor, Minister Ali Sabri. Normally as ministers what we do is really that we made some recommendation to the Council of Legal Education. It is an independent council chaired by the Chief Justice, and representatives, members are there from the Minister of Justice, the Attorney General, the representatives of the bar associations, and the principal of law college also there. Now they discuss and they decide, but before they make it a rule, they will have to get the concurrence of the minister. Obviously that they may have sought the concurrence of the former minister, that he has given the concurrence and that has been gazetted. But certainly if there is an issue like that, it's good that the people come out and present their problem, otherwise we can't understand what their problems are. Now there is an ongoing other issue with regard to the language.
Yes.
From just this month onwards, that all the papers to be written in English. That yes. There are so many concerns that if certainly these problems you can forward it to me, I can discuss with the Council of Legal Education, because it is not a matter where the minister alone can take a decision.
Right. So I think that is
one way it is good, because yes. With the politicians are going to take all the decisions, that also might create so many other issues. Now this is with the concurrence of the minister, council takes the decision.
In concurrence with the minister. Yeah. Actually, yes, Honorable Minister, so I'm a law college student myself, so a lot of constant changes, like one after the other, so changes are very, it's on an expressed rate, so I think the existing batches might be finding it very hard, so one year you sit for the exam in one style, and then the next one it's a whole different order, so it's very chaotic, because
one way that Sri Lanka is the most successful country in the world, changing its policy day by day. If you look at that, we don't have the education policy. Even that tax policy is an issue these days. Last night we discussed about it in the media. Now the Sri Lanka, the people, the business community, that entrepreneurs, they can't survive. The reason is that every time we change, we are not certain on any matter. Now if I am the finance minister, I say that from this particular sector 10% income tax, when another next minister comes and I will make it 20%. The whole system could collapse. Now that is what is happening. Now with the greatest difficulty since 2015, that we were gradually increasing the revenue. That our target was just to increase the revenue, that's the increase direct revenue instead of the indirect taxes. That we came to a certain level. But all of a sudden in 2019, when the new president was elected, in a country where we were getting only 1,900 billion, he gave a tax cut, reducing by 600 billion. Now what happened? Now again when we'll have to increase it, that will have to increase by 3 times. Because last 3 times that we already suffered, but that was a tax cut which was not demanded by anybody. Likewise, even in the other fields, what he says is correct, that constant changes are biggest problem. Even for students, that there has to be a policy in the law college or law faculty or universities, at least for them to have the knowledge 10 years or 15 years before as to how that the system going on. If it is a rule made by the law college, then at least that system must continue for a long period, unless of course very essential and urgent requirement is there. Then if you are going to change at least even tax policy, even if you are going to change, at least you must give 10 years prior notice to the people. Then people will get adjusted it. Because the country is not run by the economy or the money created by the government. Government can't do it. It's done by the people. It's the duty of the government is to, to make the relevant laws, That is just to uphold the rule of law and give the confidence that all are equally treated, and to make that infrastructure facility and have a tax policy. As to how that people think that the Lee Kuan Yew developed Singapore. No, he didn't do. What he did was he made the environment and gave the confidence to the international community. It's a country that rule of law prevailing. You can take $100 million in your hand from the top to the Singapore, you can go to the down point. Nobody will disrupt you. But here that we can't do it. That is what the government should do. If the government do that, it's government's duty. The rest of the things are being done by the people. You need not teach the people to grow the economy. They know how to do it.
Right. So also, Minister, in terms of family law, if we take, these territorial laws, there are amendments being brought to Kandyan, Tesavalame and Muslim laws. So you can just...
there are special laws in Sri Lanka. It's a very diverse.
Yes.
One, it's good, but sometimes it's difficult for practitioners, but it is good to, the learn and know the different systems. Of course, in my case, I am quite interesting that in last year, I published a book on family law. It has covered each and every aspect of the family law, including the special laws. We have 3 special laws. Now that in the private lives and our inheritance rights and property law, we are governed by the Roman Dutch law. Then there is the that some native laws in the upcountry Sinhalese, the Kandyan law. Now I have presented a bill to change it, to make some amendments. Then for Muslims, there is a Act Muslim law, divorce and marriage and divorce. Tesavalame law is there. We were concerning about the changes only in the Kandyan law and Muslim law. The Kandyan law, that's all have agreed, and the bill has come. 2015, when I was the minister, then I appointed to look into this relevant amendment in the Muslim law, and it was chaired by the former Supreme Court Judge Salim Masuk. Then it continued even after that I left the ministry, that had been continued, and now there is another committee appointed. They have almost come to an agreement, especially with regard to the age of the marriage. In principle, all have agreed, and now there is no issue. All are agreed that it has to be, commensurate with the other laws. It should be 18 years. That's the international standard, not because of anything else. It's due to the medical reasons, that it's the opinion of all in the medical sector. A girl of age below 18 years is not ready for a family life. That we have to take into consideration. They have agreed. Then there are issues about the Kati court. There also that we have resolved, we have agreed. Then only issue is about the polygamy, that especially that's members, female members in the committee are against it, the male members are for it. Now that there are some controversy, that they have given us a report with few options. Now again that there was some group came and met me, some senior lawyers. Then again that I wanted them to discuss together and to have the final report next week. Then we will go ahead. Now if it is a special law, as a government, that we do not get involved on our own, unless that there is a request or interest in the particular community, and if they say that they need such reforms, only that we will do. Because those are very sensitive. Those are that's they are mostly affect their personal life, and therefore that's we handle that kind of laws very carefully. Not like that handling criminal cases.
Yes. Also, Minister, if you talk about the matrimonial laws, it's very fault-based, but now the times have evolved, and it's necessarily not always fault-based, where people, where the government gets involved in deciding whether people should stay together or
that
not.
Also that there were so many dialogues, especially in fact that our biggest issue in this field is in addition to the 3 grounds, that is that adultery, malicious prosecution and
infidelity.
Not infidelity, that's not infidelity, that's
it is.
I will come to that one. In addition, impotency.
Sexual impotency, yes.
Those are the 3 grounds recognized in the General Marriage Ordinance. In addition to that, I am also concerned that most of the marriages are in the present society broke down on some other grounds. Mostly that's incompatibility, not compatible. And in some of the domains that they have recognized that as a ground for divorce. In Sri Lanka, we were discussing, but there are a lot of oppositions, especially that in the Christian society, they don't like to go beyond this one, because the religious teaching is that those who are put together by the God should not be represented. That is the policy. On the other hand, even from the other religious communities, I have spoken to the religious leaders of all the religion. They also have expressed that they are, the different views. Those are the matters that again we'll have to engage in a, very serious dialogue on it before we take any decision.
So actually, Minister, so law is actually, it plays a key role in our life, whether it will be personal or whether it be criminal, or there's no avoiding it. So because we are all in this system, but the times evolve, people evolve. What society was 10-20 years ago, the society is not the same. The generations are different, and but as legislators, as lawmakers, so what is being legislated here is what the courts execute. So this lag in terms of reforming the justice system for all these years, why do you think that there is very little in such an impactful field? Why is reform so
There
slow?
are many reasons. So we are far behind. The world is going forward, that we are lagging behind.
Even India is,
India also,
this is very
that's a big
progressive,
development. There are few reasons for it. That in our legal system, there is no, that any mechanism or proper procedure to change the attitude of the people, the attitude of the judges, the lawyers. They don't like for changes. One reason. But that is not that much significant. Now, who has to make the reforms? Whose obligation is that? Who are the lawmakers? Parliament.
Yes.
The Parliament is lagging behind everything. Parliament must, they must come forward. They should take the leadership, because in the Parliament that we have been entrusted only 2 tasks. We have not been entrusted in many tasks by the people. They elected us for us to do 2 things. One thing is to make policies, formulate policies and transform them into the law. That is the first duty. The second duty is to control the finance. Exclusive powers given to the Parliament. Are we doing it?
That's a good question. I think the people are also asking the same question. Are we doing it?
We are doing it a minimal way, because that we are doing everything else other than those 2.
Yes.
Now, how many discussions are going on in the Parliament about the law reforms? If some minister on his own brings a law, then there is a consultative committee. They just come and just talk, even not properly studied. What is the law? What is the the purpose behind these things? Not studied enough. I think that we must teach the law to all the Parliament members. No, I am not ridiculing him. This is a factual position. Even in 1970, that Mrs. Bandaranaike was of the same view. And therefore, what she did was, she relaxed the law, the enroll into the law college. And any MP without any basic educational qualification were permitted to become law students. Now, not that I am supporting that position. But here, in fact, that there has to be some system. We are thinking about in the Parliament that we must have some interaction among ourselves about the laws. We are talking about the policy, we are talking about the conduct of the president, the conduct of the other ministers, and various things. We are attending to funerals, we are going for dana. The members of Parliament have given priority to those things. That is because during the J.R. Javadana's period, that he brought that national politicians in the Parliament also to a level of local government politicians. Now, as a result that he made some, you know, the allocation that he made some allocation. Thereafter, what happened was that with this allocation, maybe 10 million or 5 million, that we start making roads, constructing road, repairing, you know, that's the public institutions, and providing water, electricity. Now the same thing is done by the members in the local council. Then the people just think that's no difference, that the parliament member is doing the same thing. He also just attend to funerals and things like that. Local government member also do that. He do the construction of the road. We also do that. We all are same. Now therefore members of the parliament have, most of the members, I don't say everything, majority of the parliament members have forgotten their task. They think that they also must work like, you know, local government members. That is the blunder that we have gone wrong. Now, as a result, what happened was, if you have to, you know, win an election, you will have to come down to a level of local government MP. Unless that you come down to that level, they won't, you know, give their preference or the vote. Therefore, all the people, politicians have got used to that. We will have to do this change. That in parliament, it is not there to, you know, for parlor talks. That is the place where that we must talk about the matters of national importance. And we'll have to talk about the reforms, that as to how that we make policies. That is the culture that we are trying to bring in.
Right. So you're the Justice Minister, also a member of the cabinet. So do you have a vision in plan for this?
Yes. In the last cabinet, I presented. I made a request, which was approved, to have a parliamentary select committee to have the reforms on all the electoral system. Sri Lanka is a unique country, that's, you know, everything is diversified. We have 3 systems of election, the parliamentary one system, provincial council another system, local government completely different system.
It's very diverse, a very small country but very diverse. Right, so
diversity is not bad.
Yes.
Diversity is good if it is for the benefit of the people.
Right. Okay, so it's I mean, didn't feel time passing, so it's been almost 1 hour, so we have to wrap it up at 10:30. Honorable Minister, thank you for joining in with us, and thank you for all your questions. So we tried to accommodate as much as we can. We will be back with another interesting LK Ask MP session soon. So thank you for joining in with us, and Honorable Minister, so this is why the communication department we bring in, because as people representatives, I believe that the people have a right to directly engage, and not always they get that opportunity. So to connect with their representatives.
I think that your view I fully endorse, because in 2006, when I was the chairman of the COP, that I presented very controversial reports that I got into a lot of trouble by doing so. It's not an issue. From that time onwards, that I was fighting very hard just to open certain things to the people. I wanted the COP and COPA proceedings to be open to the media, because people should know what is happening in the parliament. In fact, that the World Bank, they appreciated what we did in the COP committee. They gave us a grant of 100 million rupees. That is to, you know, that give that infrastructure facilities for that kind of things. But unfortunately, that money was taken by the Treasury Secretary. Those days he didn't give a single cent to the Parliament.
So has justice been served? I mean that is a valid question. Has justice been served? So I think that is also a big problem the society faced. They don't have faith in the justice system, as I think previously. I think somebody.
But conditionally. Because we can't say that the people have no faith in the justice system. In fact, that the people have lost the faith in the parliament, legislature and executive.
Right.
It is not happened today. That happened, you know, during last 3 to 4 decades it happened. But thanks to the judiciary, the people still believe, and people still have the confidence. That is why we are surviving in a democratic society. Right. If not for the judiciary, you can't think about democracy in this country.
So, Honorable Minister, do you have any vision to strengthen it further?
Certainly. That is why I bring all the laws to make, not only through the law really, not only through the reforms that you can do it, that there has to be, you will have to attend to that from many angles. The first thing is the education, that make them aware, training programs, the interactions, all kind of things. In addition to the while the reforms are going on, we'll have to attend to those matters seriously.
Seriously. Right. So we hope that during your tenure you'll be successful in all your visions and goals for
I need to be
reforming.
successful. If the country is
Country
successful, that's more than I'm happy.
So as to strengthen the justice system as you wish. So I think that's what the people want as well. So thank you for your time. Thank you, even if it's a non-sitting day, for coming and engaging with the public. So thank you so much, and thank you everyone for joining in and sending in your questions and connecting with the minister. The more the engagement, the better. The more the transparency, the more the accountability, which is what Parliament wants, to create a platform which fosters that. It's high time we see beyond the traditional and the conservative ways we've been doing things.
Anyway,
so
thank you very much for giving me the opportunity to talk to the people.
So we'll meet you again. Thank you and have a good day.